and Jody, you'll notice that this is a common type of question in that it basically converts it into a true-false question. So the purpose of registration is to allow for the detection of management fraud and prevent a public offering of securities when management fraud is suspected. Notice that management fraud appears in there twice. Is a document that's prepared by management going to detect management fraud, or does that expect too much of the registration process?
I think it expects too much.
So Taylor, let's look at the second one. The purpose of registration is to adequately and accurately disclose financial and other information which investors may determine the merits of securities. Notice, Taylor, is that a much less ambitious objective? And in fact, it seems like to me that's a textbook definition of what it does. Therefore, Taylor, the answer is B as in boy. Jody, you agree?
Yes.
Question number 2. Delaney and Brandon. The prospectus for a sale of a not-for-profit corporation contain material misrepresentation due to negligence of the person that prepared the financial statements. So, I guess my question is, Delaney, a two-part question here. Number one, is a not-for-profit required to register with the SEC?
No.
Number two, does that mean that the SEC cannot regulate and prosecute fraud?
No.
So therefore, it seems like to me, let's go through the answers. Brandon. Yes, because securities are required to be registered. Well, Delaney just told me that's wrong. They're not required to be registered. Yes, because the misrepresentations were material, and let me put that aside. No, because the securities are exempt from registration. Well, Delaney says that they're exempt from registration, but that doesn't mean that there's no potential prosecution for fraud. Or D, no, because only the issuer was negligent. And who was negligent here? I'm not sure, Delaney, there's any indication there's negligence. It's simply misrepresentation, which could have been intentional. So therefore, Brandon, the answer is
B.
B is in boy. Delaney, you agree?
Yes.
Okay, good. Question 3. Sydney and Michael. One of the elements necessary to recover damages if there's been a material misstatement in a registration statement filed under the Securities Act. So Sydney, tell me what the law is. You have to show that it was material, you have to show that it was misleading, and you have to show that you suffered a loss. Okay, so Michael, with that in mind, issuer and plaintiff were in privity of contract. Michael, what does privity of contract mean? We're in a contract together. We have a relationship because of a contract. But, Michael, I don't think that can be the answer because the purchaser of the stock is not in contract with the people who put the registration together, who were suing. So that can't be correct. B, issuer failed to exercise due care in connection with the sale of the securities. Put that one aside. Plaintiff gave value for the security. Sydney, usually you acquire stock by purchase, but Sydney, who am I talking to? Who's been answering for Sydney? Oh, Delaney, I'm sorry, Delaney. Linda, know somebody's here before you talk to them. So Sydney, I suppose that your parents give you some stock for graduation. So therefore, you did not give value for the security. Does that mean that you have no cause of action under the Securities Act?
No.
So that can't be correct. And then D, Michael, a plaintiff suffered a loss. Therefore, the answer, Michael, is D. Talini, Sydney, do you agree?
Yes.
People in that direction. Question number 4. Question number question number 4. Who had 4? Sydney, did you know 4? Greg and Kobe. Kobe, the Securities Act of 1933 provides an exemption for registration for bonds issued by the city of St. Louis. Yes? Craig, securities issued by the Red Cross. Yes. Therefore, Kobe, since I said yes and yes, the answer is A. Greg, you agree?
Yep.
Question number 5. Alex and Candace. Which of the following statements concerning initial intrastate, and Alex, tell me what intrastate means, as opposed to interstate.
In the same state.
So everything happens within the state of Missouri. So now that I know what intrastate means, then the offering would be exempt from the registration requirements of the Securities Act of 33. Offering would be subject to the registration requirements. The offering would be regulated by the SEC. Seems like to me Candace, B, and C are the same thing. And D, the shares of the offering cannot be resold to investors outside the state. I know of no such rule, therefore Alex thinks there is A. Candace, you agree? This is a summary of the 1933 Act, Regulation D, which exempts corporations from having to file if these conditions are met, and we talked about this last time. So now let's move to the theme. The purpose of the 1934 Act is to regulate and control securities transactions in order to protect investors. What is the difference between the theme of the 33 Act, Jody, and theme of the 34 Act? So Jody, the 33 Act is concerned with,
Making sure that there's no vending fraud.
so initial registration?
Yes.
Of course, now that means that it would apply to initial public offering, but it would also apply to a subsequent offering maybe 10 years later. While Tellini, and you'll notice you're Sydney today. Tellini, the objective of the 34 Act, while 33 is concerned with the initial registration, 34 Act is concerned with things like insider trading and fraud and so forth. So it's concerned, Jody, with subsequent events.
Yes.
And Jody, what happened was that they passed the 33 Act, and then they said, well, we need to think about what happens after initial registration, because there can be problems and we need protections for the consumers later. The other thing that the 34 Act is concerned with are the annual 10K statements that are filed with the SEC. Securities and Exchange Act of 1934 provides for registration of security exchanges, brokers, dealers, and national security agencies and associations. And here, Tellini, I'm talking about the registration not of the shares, but of the institutions, of the stock exchanges, and so forth. In addition, Tellini, any person owning at least 10% of the stock must file with SEC. It's a simple annual statement saying, I own 15% of XYZ, and I have this relationship to the corporation, and during the year I sold 3% to Tellini and bought 5% from Alex. Applies to company with $10 million of assets and 500 or more shareholders. Tellini, here we do not consider, when we say, I should say 500 or more unrelated shareholders, because you and your husband, Tellini, would be treated as one. You and your children would be treated as one. Note that the number drops below 300, and Alex, how could that happen? Oh, okay, if we bought back treasury stock. So I have 500 shares, and then I bought back 200 shares, and they're listed on the stock exchange, and terminate the need for filing. And the theory here, Kelsey, is that if you're listed on the stock exchange, then that provides some protection already, since they will have some anti-fraud provisions in mind. Securities Act of 1934, Section 10B, SEC Rule 10b-5 prohibits use of any manipulative or deceptive device or contrivance in violation of the SEC rules and regulation. So Katie, everything has to be above board. Section Rule 10b-5 continued prohibits fraud in connection with the purchase or sale of any security. All cases concerning securities traded on exchange at OTC, what is OTC? Over the counter or private sales. Insider trading is to purchase or sell securities on the basis of information not available to the public. And I think, Kobe, if insiders can make a killing on inside information, then that diminishes the confidence that the investors have in the system because they can manipulate it. So that's a very important issue. And that's something that will get you in trouble in a hurry. Any material omission or misrepresentation in connection with the sale of purchased securities may violate 10b. Examples of material facts and disclosure, fraudulent trading by the broker, dividend change, and Kobe, if you think about, what if it had been our policy for the last 20 years, every year we pay a dividend twice a year. And then we've decided, the board of directors have decided, well, we need to, because maybe we have a bond issue that is coming due, and so maybe we ought not to pay as much in dividends, and so instead of having a dividend twice a year, we'll have a dividend once every other year. Is that something, AJ, the public would want to know? Because it could be, AJ, if you were invested in a company for retirement purposes, or to provide for your children's education, then you don't really care as much about the dividends. In fact, Katie, if your objective was to prepare for your retirement in 30 years, then you would prefer that they reinvest the profits in the business. However, Kelsey, once you got to the point of retirement, then you want the dividends. So therefore, in the finance literature, there's something called the clientele effect that says, Kobe, that investors choose corporations partly based on their dividend policy. So again, an example is, if I'm trying to save for retirement, I don't really care about the dividends. Once I go into retirement, then I want the current income, and I probably would change my investment motives. But it makes sense then that, AJ, this would be required to be disclosed. New discovery, process, or product, significant change in the firm's financial conditions. Perhaps Telini, we had substantial foreign investment, say in Indonesia, and the Indonesian government has kicked us out of the country. Well, that would be something that investors would want to know. Potential litigation against the company. If we're facing, Alex, a $20 million lawsuit, that would be something that should be disclosed. SEC versus Texas Gulf on page 824. Brendan, tell me what the facts are.
So Texas Gulf Sulphur Company, they did an aerial survey. They have on a large area of land in Canada. Then they drilled a hole and found high mineral content. They didn't disclose this to the public, and officers and employees made large purchases of the company's stock. And then they did additional drilling, and they were expected to find 25 million tons of ore. And then their stock price shot up. So the SEC brought up a suit against the officers for violating Rule 10b-5.
So I think we were in Canada. I think the wells were in Canada, and we're very successful. And of course, the nature of the business, Brandon, is that this is high-risk business, and you can drill 10 holes and 8 would be unsuccessful. So you really have to maximize the 2 that are. And not only did they not disclose it to the public, but Brandon, when the press released it, they minimized it and said, no big deal. It's not going to be a major fine, it's a minor fine. And then, in the meantime, the insiders bought a lot of stock. And then, once it was released, the information was released to the public, the stock price rocketed. And therefore, the SEC is charging them with insider trading. Now, Megan, Alex, is that a good description?
Yes.
Megan, what's the issue? thought the information they had was material, and because Cellini, not everything is material. And Cellini, what did the trial court do?
They said that it was definitely material.
The trial court said it was not material,
Yeah, the trial.
and ruled against the SEC, and the SEC appealed. And then on appeal, Candace, what did the court do?
They reversed the first opinion. They said that anyone who's like in possession of insider trading or insider information must either like disclose that they have it or not trade.
And it seems like to me, Linda, this is, but again, Linda, the actual trial itself, if we looked at the transcript, would be 300 pages long. And so, and the court decision only gives us a brief summary. And also, Linda, you have to keep in mind when you read the court decision that the author of the decision has already made up her mind how she's going to rule. Therefore, she would choose evidence that supports her ruling. But keeping all that in mind, based upon the 2 pages that we have, of the 300 pages we could have, this looks material, doesn't it? And I think, Brandon, what was perhaps the most damning thing is that it's not so much that they did not release the information, is that they tried to suppress the information which was leaked to the press. Like, it's no big deal. It's no big fine. It's like just another Monday. Okay. So I think this is clear. So Megan, you think this is a clear example of insider trading? I think so. To continue, the tipper and tippy theory insider fiduciary duty must be breached. So therefore, Kelsey, is it necessary that the insider herself has to benefit? Suppose, Kelsey, that you're an insider and you tell your sister. Are you just as liable?
Still not fair,
Not fair? Why is it not fair?
because the other average Joe.
Oh, I'm sorry, it's not.
It's not fair
To the investors, okay. I thought you were saying it's not fair that you're punished for.
No.
But then again, Kelsey, your sister would also be liable, because you'd be liable because you provided the information. Candace, the sister would be liable because she took advantage of it. Misappropriation theory, one wrongfully obtained inside information. So, Alex, you commit a burglary. You're not even. I just thought of that, David. A burglary really is an inside job. Let the tape reflect. It was another attempt at a joke that fell flat. If you think about it, Candace, I mean, who's the ultimate insider? It's the burglar. Also, take a note, if you have to explain it, it's not funny. But sometimes, Linda, you can melt the fact that people don't laugh. Or do you move on? Recapture, to continue with the rules, requires recapture of all short-term profits by insiders, those only in 10% of the equities of the corporation, applies to stock, warrants, options, and securities. So I think Candace, they mean business here. Regulation 14.1 of the 34 Act. And Candace, I would not be concerned so much with the section numbers. I would be concerned with things like Regulation D, but I would be more concerned, AJ, with what the sections provide. Remedies for violation include injunctions, or damages, or so forth. Signature is required to prove civil or criminal penalties under 10B and Rule 10.5, not required for 16B. Kayla, what does that mean?
It's intentional knowledge of wrongdoing.
So it's intentional. So therefore, so I do wrong and I know I'm doing wrong. Intentionally wrong. And so my code, negligence would not qualify. Negligence, by definition, if I'm negligent, I don't know what I'm doing. I don't do it intentionally. So here, Kayla, the plaintiff must show not only that you did it, but you knew what you were doing and you did it intentionally. So it's not simply, Michael, an oversight, it's intentional, which is a higher standard. Notice here, AJ, we have a pension fund who's suing Boeing. So AJ, tell me what the facts are here. And it will be interesting, AJ, because Taylor will get a different result. So it's going to be interesting to see how this is different from the golf case. So AJ, tell me what the facts are.
So Boeing was supposed to make this plane, I think Dreamliner, there you go. And they were scheduled for June 30th to make it, and things kept happening, but they assured everyone that the plane would be built and take off on time. The first flight would have no problems.
And by first flight, what does that mean?
Uh,
First flight is an industry term that means we will reveal to the press. So therefore, we'll have our first flight, press will be invited, and then we'll promote it and so forth. And that's supposed to happen in June '09, but it failed some test. And then they delayed it until December.
mhm.
Okay, so those are the facts. Tell me, Katie, what's the legal issue?
It's if they violated section 10B and rule 10B5, where if they were manipulative or deceptive and that had any material omission of facts.
David, you agree? So it seems like it's the same basic issue as before. But notice and in a sense, David, the result of trial was the same. That is, the trial court ruled in favor of Boeing and against the SEC, but then Matt on appeal, remember Matt, in the earlier case, the trial court ruled against the SEC, but in the earlier case, the SEC reversed. What does the court reversed? So what does the appeals court do here?
This time, like, the judge dismissed the suit, dismissing the suit was affirmed, so like they said, Bowen was right.
So let me get to terminology now. So Matt, the trial court dismissed, which means it did not even go to the jury. And then the circuit court said, we agree. So tell me, Taylor, what's the reasoning?
They said that they didn't have to disclose every time one of their tests failed because they would have to do that a lot, and they were still predicting that the flight date would be on time.
But to me, this seems like a big deal to me. That is, and it's not like it's a mouthwash that they're developing. It's an airplane. You know, it's not. And we're talking about millions of dollars in development costs. So it seems like this is a big deal. So how is this different? And sometimes, Taylor, you just have to say it's sometimes difficult to reconcile court cases. But one of the things to me that the court says in this case is that an investor should know, that the knowledgeable investor should know that product development is a risky thing. Therefore, they should not be surprised. Brendan, is that different from hitting a successful well? I think so. That is, you don't anticipate, Kelsey, that every day you will be successful in drilling, because most days you will fail. However, EJ, you anticipate that product development is a long, drawn-out process, and Taylor, it's not that they didn't deliver the product, they simply delivered the product 6 months late. Maybe, Candace, in hindsight, Boeing's problem was being too ambitious with their launch date, and of course they want to do that because the sooner they launch it, the sooner they can solidify the sales, and the sooner they can make delivery, and the sooner they can get paid. So, what do you think, Alex? Right decision? And again, I'll preface this by saying we only have 2 pages. And I'm sure the pension fund is pissed. I'm sure, Taylor, the pension fund is saying that this is a gross miscarriage of justice, one of the worst in American jurisprudence. What do you think? Alex, good decision?
Yeah.
Based on what we have, I think it's a good decision. And I think it's good, Linda, to talk about a case that goes for the SEC and have one that goes against them. Criminal penalties, person faces $5 million and 20 years in prison. That's a long time. $25 million for a partnership or corporation. Note that the SEC does not prosecute cases in terms of prosecution over a Justice Department. So therefore, Linda, it's the SEC that investigates, but once they determine that there's wrongdoing, then they turn that over to Justice Department, because the Justice Department, which makes sense. Linda, the SEC has trained investigators, but not prosecutors. So therefore, the Justice Department will actually go to court. Sarbanes-Oxley provides for 25 years in prison if the misrepresentation is willful. And again, Candace, were they trying to make a point? We'll see if they did. Violations 34 Act, civil sanctions, both SEC and private parties can bring action against violators under insider trading and securities fraud. Private parties may bring action for violations of both. Issue spotter number 1 on page 835. Ian, read it to us, and Greg, give us the answer, or summarize it for us. And
The corporation wishes to issue certain securities. It must provide sufficient information for an unsophisticated investor to evaluate the financial risk involved. Especially the law involves liability for making a false statement or omission that is material. What sort of information would be an investor consider material?
so one party says, Greg, that, I'm sorry. So one party says, Greg, one party says that, what's the answer, Greg?
Like in the prospectus, it would probably be something like listing corporations, properties, and business, and what they would do with the proceeds from the sale of the security.
So generally, materiality can be defined as a change in this fact will change a investor's decision making. So let's think about, Greg, a $20 million lawsuit. We've got a $20 million lawsuit. Is that material? And let me suggest that, yes, consider a company who has gross revenue, annual gross revenue of $100 million a year. Is a $20 million lawsuit material?
Yeah.
Yes, it could wreck the company. But what about a $20 million lawsuit against Microsoft? Arguably, that would be petty cash. They could make that up in a day of revenue. So materiality depends on the facts and circumstances of the case. Issue spotter number 2, Candace. Tell me what the issue is, and Alex answer the question.
So Lee is an officer of Magma Oil, and he knows that a geologist has just discovered a new deposit of oil. And the question is, can he take advantage of this information to buy and sell the Magma stock?
What do you think, Alex?
No, because it's a new discovery, so it's insider trading.
Can you speak up for the camera?
No, because it's a new discovery, so it'd be insider trading.
And as Kelsey said earlier, it's not fair. It's not fair to the other investors that you benefit from this information. And therefore, and do you think, Candace, that in practice that this business of insider trading would be a big, do you think that in practice there would be some cases where it's this crystal clear, but in the majority of cases it's arguable? So now let's go to business scenario 42.1. Candace, tell me about this. And then Linda, You can answer the question for me.
So there's a business, Estrada Hermanos, and it's doing business in Florida.
Oh, Florida, oh,
And it's gonna sell $1 million worth of common stock to the public, but only within the state of Florida. And one brother says it does not need to be registered with the SEC, and the other brother does.
so we have what amounts to a civil war. Except I'm still on the wrong page, aren't I? We have what amounts to a civil war, and so Linda, which brother is correct? Do we have to register or do we not?
You don't have to register with the SEC, but you do.
But there is a but. In fact, I would say there are two buts to this. Number one, we don't have to register with SEC, but if there's fraud, the SEC can prosecute. However, we do have to register with the state of Florida, and some states impose stricter standards than the SEC. Florida is not one of them. Business scenario 42.2. Kobe, tell me about that, and Cindy, give me an answer.
So a company that operates within different state lines is splitting their stock 2-for-1.
So
300,000.
we have 300,000 shares,
Yes.
and then we're going to do 2-for-1 stock split.
So the question is, do you need to have a prospectus on the new issue?
So I am issuing new stock, but I'm not getting new money in. And Candace, I don't have new investors, because who's getting the additional stock? The original investors. And so, Kobe, does this need to be registered? No. So we've had two examples where we don't need to register. Candace, I told you in the first day of class how when I took the CPA exam, I failed audited twice. When Dr. Harrison took the CPA exam, he failed business law. And he says that one of the questions that he was asked was about blue sky laws. And blue sky laws are the state equivalent of the SEC. And Harrison says that he had no idea what blue sky even meant. So he blames that for having to take this law again. So he told me, he said, make sure you talk about blue sky laws. So I did. The Private Securities Litigation Reform Act of 1995, external auditors must include procedures to detect illegal acts. And I think, Candace, we already had an obligation to do that. But this imposes penalties in addition to what already existed. Identify related party transactions, we already had a duty to do that. What imposes new penalties. Evaluate whether clients have the ability to continue as a going concern. Kobe, going concern is a very important concept. What's it mean? And then Megan, Kobe, what does it mean and what should auditors do about it? And Megan, why do investors need to know that? So Kobe, what is it?
It's a principle that, or assumption that a business can be able to continue its operations.
So there's a basic assumption that the entity that we're auditing is going to be here 5 years from now. It's a going concern. It's not going to go out of business this year. And if we violate that, then Kobe, what do we have to do? Issue a qualified opinion, and in the qualified opinion, we'll say something like, we don't meet the basic assumption that we're going concern, and this is why. Now, Megan, why do you want to know that as an investor?
Because you want to know if the company has a threat to liquidate or if they're going to keep issuing.
Yeah, and Megan, if you're preparing, if you're saving for your retirement, you don't want a company that's going to be gone in 6 months. And Kobe, if we issue a qualified opinion on this, would that hurt the stock price? Big time, because this is an important assumption that's built into the model. Dodd-Frank was passed in the aftermath of the financial crisis of 2008. It seems SEC authority over derivatives. I know nothing about derivatives. You can ask Sandy Fleet. Are you doing derivatives yet?
Yeah.
Gives you a headache, doesn't it? And I think one of the, Katie, one of the arguments about derivatives is that they're so damn complicated, nobody understands them. So how can you regulate what you don't understand? And extends the authority of the Fed to look more closely at bank risk, because, of course, that was one of the problems with the crash of 2008. The end of chapter problem. Tell me, Kelsey, what's going on, and then we can answer the question. So, Kelsey, what's going on?
So Emerson is a guy that's the CFO of an electric company that's only serving Montana and North Dakota. His company is in the final stages of taking over a natural gas distributor that only operates in North Dakota. And this guy mentioned the long hours he's been working because of the takeover to his uncle. His uncle then bought $20,000 worth of the company that Emerson's company was going to take over and sold it at a large gain after the takeover happened.
Good summary. So, David, all this happens on a fishing trip. You should be careful who you go fishing with. So he gets a hot tip that there's going to be a takeover bid, and there's no evidence, Kelsey, that the nephew's doing anything wrong. He's just making small talk over a fishing hole. Although Candace, he's being somewhat careless. But it's hard for me, Kelsey, to be sympathetic to the uncle. Because the uncle, AJ, knew what he was doing and acted quickly and took advantage of this information. And Alex, this information the public did not have, to use Kelsey's words earlier, it's just not fair. Okay, so question number one. David, what's the question?
Does the thing in North Dakota have
The thing in North Dakota have to be registered, and Kelsey, the answer is?
No, because they're only in North Dakota.
And also, are they issuing new shares? So what they're doing is they're going on the market and they're buying up the stock. So therefore, it's not the corporations that issue new shares, it's they're going on the market buying existing shares. Therefore, this does not need to be registered. Now, Kelsey, if they were doing in tax lingo a type B reorg, where they were issuing, instead of buying the stock, they were issuing their own stock, that would be a different case. In this case, they're simply engaging in a transaction on the market. Question number two. Kayla, question, Matt, answer.
Did Emerson violate section 10B of the SEC and SEC Rule 10b-5?
And Emerson is the nephew. Emerson is the insider who was careless. Matt, what do you think? And Matt, think about this as a prosecutor.
I would say he did, because I mean, like, he was just being like real careless, like with what he was saying. So he wasn't really like, I guess he didn't realize he was giving him information, but like all the information he was saying about it was very like insightful into what the company's gonna be doing. So it's like knowledge that other people might not have.
I think that's right, but I think, Matt, this would be a very difficult case to prove, because you'd have to prove that he had some intent. So you can prove, I think Candace was incredibly negligent, but I don't think you can show that he had intent. Now, Matt, if you can show that he did this to benefit his uncle, or if you are, Matt, and again, just look at it, Matt, from the prosecutor's case standpoint, let's suppose the uncle bought the nephew a new house for Christmas. You know, that's, the sort of thing that you do every year. Then that would make a stronger case, because then, Matt, you could show that the nephew materially benefited. But this case, my guess is that justice would not even bother to go after him, because it's going to be a hard case to prove. Now, Kobe, in question 3, what do we have in question 3?
What theories would a court use to bulk up a lot?
And Wallace is the uncle. So what's the answer here, Julian?
The Tipper-Tippy theory, because he took advantage of the information that was given to him.
And clearly, assuming the facts are as they say they are, clearly the uncle's in deep trouble. But then, let's think about it again from a jury standpoint. To me, are juries terribly sympathetic to insider traders? No, because they think that in fact, the general perception of the person on the street is that the system is stacked against them. And this is even more evidence of that. But the uncle could say, Michael, maybe he had information from other sources, maybe he had a good guess. And how, Matt, would you prove that this conversation happened? There's no record that the conversation happened. Maybe the fish, and I think the fish are really upset because fish generally don't like fishermen, fisher persons. But assuming that we don't have, and I think, Talini, there's a real evidentiary question here. How do we prove that? But if they can prove it, I think the uncle is in trouble. Question number 4, AJ sort of changes the story and asks a different question.
Under the SARS, Oakley Act.